But legally, if you're on leave, you are on leave. Nobody will take you to court for not having performed duties, whereas you are on leave. And leave, again, is a provision in the law.
Actually, Mercy, what the employment law says, Employment Act 2007 says, uninterrupted first 14 days. Uninterrupted. Those are the words.
What is sexual harassment? What are the provisions? I think we need to look at the Sexual Offences Act in detail and understand what constitutes sexual harassment in the workplace.
I hope you had a wonderful Thursday, and we are going to crown it by understanding some of the issues that surround changes in coming up with policy development and implementation. And we have a pretty good speaker who has been in the game of policy development. I am sure what we are going to gain. Milton, you're welcome as well. We are going to start in the next 1 minute or so. So look for your mug of tea or coffee or hibiscus for those people who love variety, so that you can enjoy until 7:30. I hope you have your notebook so that you can be able to jot some points down. I have my notebook here. I can't wait to hear Mercy Mwirigi tell us what she has in store for us. Hirali, thank you very much. Raula, thank you very much. Rhoda, thank you very much. Milton, thank you very much. Tyson as well. Jacqueline, thank you very much for creating time to come and listen to this webinar. Ladies and gentlemen, my name is Richard J. Magoma. I am a human resource practitioner. I have practiced human resource management for over 13 years. And it is something that I love doing and I'll continue doing. I'm also an event MC, just in case you're looking for an MC. Now, Dendel Consortium LLB is a HR consulting firm. We do recruitment, team building, training, interview preparation, LinkedIn editing, CVs, and many other services. But tonight, we are going to have our good friend, Mercy Mwirigi, who is a very seasoned agile. And when I say seasoned, I really mean seasoned. She has been in the game for a long time. She will tell us how long she has practiced HR. She is very passionate about employees being productive to the employer, and equally the employer getting value out of the employee that they have hired. She's also passionate about creating a positive work environment where people thrive, where people unleash their potential so that they can perform at the highest level that they can be. Also, Mercy Mwirigi is a certified mediation expert and trainer. So if you're looking for alternative dispute resolution, Mercy is the person that you should be able to recommend so that that problem can be sorted out. Ladies and gentlemen, join me in welcoming Mercy Mwirigi. Mercy Mwirigi, you can also add other things that I have forgotten because I've not started taking my coffee. So you can add other things. Welcome. Tell us what you have for us today so that we can become better human resource leaders who transform organizations.
Okay. Good evening, Richard. Good evening, colleagues. And I'm very excited to join all of us today. It's a great evening. It's a Monday, Thursday for those of us who are Christians. It's a very special day, actually, when Jesus Christ washed the feet of the disciples. So for us to be here, I know the service normally occurs around this time. So it's a big sacrifice, and I want to believe that it is not in vain. We are going to leave this place with useful ideas and tips on how we can go and serve better in our respective organizations. So without saying a lot, as you have heard, my name is Mercy Mwirigi, and I'm a HR professional. I'm a certified professional mediator. I work at the Judiciary of Kenya as an assistant director HR. I have been in the game for so many years, over 22 years now in service, and there's nothing that I love more than shaping organizations through management of human capital and ensuring that through human capital management strategies, programs, and activities, then my organization or organizations can realize their strategic goals and purpose. So that's it about me. Thank you very much for joining this webinar, whereby we are trying to look at how do we ensure that our policies in HR are aligned to law. And we'll be looking at the recent developments in law and also recent court decisions so that we can have an idea of what are some of the changes that are taking place, and at the same time ensure that our policies are well aligned. Before I delve into the presentation, I am passionate about policies governing human resource management, because without policies, then an organization may not be able to function. And I always like reminding all of us, or most of us, that still human capital, human talent is the most important asset in an organization. So we must ensure that policies governing human resources, our employees are number one, they are lawful, and then number two, they are flexible enough. Then number three, they are fair. They ensure that we provide fair labor practices and fair decisions to our employees, being the most important assets in organization. And then once you have the human management function running well, you can be sure that the organization will go to the right places and your employees will give you the best. All right. So at the end of the presentation, should there be need, I might just take us through a few tips on what should constitute good HR policies. I know it is a whole lesson, it's a whole topic altogether, but I can give just a summary or highlights so that even as we look into reviewing our policies to align them to the law, then we can also understand what are the critical components of policies in HR, and probably how do we go about that particular review. So I'll be sharing my screen so that we can go through this. Richard, confirm kindly if you're able to see my screen.
Not yet.
Not yet.
Now you can look for it. Yes. Yeah. Okay. Present mode.
Okay.
You have disappeared again. Yeah. We are there.
Super. All right. So introduction has been done on who we are. So that's our topic for today: adapting human resource policies with changing labor laws in Kenya. And as part of the introduction, we want to ensure that we are alive to the employment framework in Kenya, which is constantly changing, through number one, enactment or amendment of various laws governing the labor practices in Kenya, and also alive to court decisions which form part of case law, so that we ensure that we are managing employees as per the law, and we all understand that failure to comply with the law then has consequences on all of us, which is costly and which is also not very good for us as HR practitioners. So we are going to be looking at two elements in this presentation. We are going to be looking at the recent changes in law, and then we'll take time to practically look at some of the court decisions that have been made. This is very, very, very useful because you were able to relate a policy issue with what the court has said. So a big segment of this presentation will be on the changes in law as a result of court decisions. I know we are aware about some of the changes. Maybe in the chat, I can request that we type in any changes that you're aware about. You could be right, you could be near right, but in an adult class, all responses are correct. Okay, so in the chat, just indicate any law or any issue that you believe is recent, then maybe we can have a look at those and evaluate and see whether we are in tune together. Okay, so as a part of laying the background, we need to understand the legal landscape under which we operate as HR professionals. Fundamentally is the Constitution of Kenya. Okay, the Constitution of Kenya is the primary law when it comes to management of employees, and secondly, followed by the Employment Act, which provides for everything in detail on how you manage employees, from the contracts, the rights and obligations, to the termination processes, to the protection of wages. All that is in the Employment Act. And then we have Labor Relations Act. The Labor Relations Act provide guidelines on how trade unions primarily operate and how they enter into collective bargaining agreements and how disputes between organizations and trade unions are resolved, or between trade unions are also resolved. Then we have Labor Institutions Act. It provides for institutions that support the government, particularly the cabinet secretary, in addressing labor issues. For instance, we have the National Labor Board, which advises the CS responsible for matters labor on everything, legal, procedural, and all aspects regarding management of the workforce in the country. And then most importantly, we have the OSHA, Occupational Safety and Health Act, which again is responsible for ensuring that workplaces are safe, employees are working in a safe and a healthy and hygienic environment. The equipment are proper, they are up to standards, including people who visit workplaces. So that is also a very fundamental law that all of us should familiarize ourselves with, and ensure that organizations align our operations to that particular law. Then finally, we have the Work Injury Benefits Act. This provides for compensation and benefits for employees should there be an injury or should they maybe contract a disease. We have occupational diseases, like for instance, if you can demonstrate that you suffer backache because of long hours of sitting down, that's an occupational disease, or many other things. Some could even be what do we call them? Long-term diseases. Maybe you've been working in a factory and you've been exposed to a lot of fumes and gases, and out of that you have maybe acquired a permanent lung disease, then under Work Injury Benefits Act, you should be able to get some remedy. So that's the law regime in the country. And I encourage all of us to ensure that constantly we get familiar with the provisions of all those components of law. So we'll now delve into the legislative changes that happened recently. And I have captured two under the Employment Act. The first one is an amendment made in 2021. And what this happened is that what happened in this particular amendment, pre-adoptive leave was introduced. When you look at the Employment Act under leave, there was maternity leave and paternity leave. But now progressively, it has been legislated that parents going for adoption also deserve 1 month's leave, and that is now law. So ensure that you have that also as part of your HR policies. I know you have a provision where we have a leave. Leave management is very, very, very critical. So if your leave provisions do not include pre-adoptive leave, then it is a high time that you included that as part of the amendments. Then the second amendment was done in 2022, whereby employers are now not required to ask for clearance from HELB, from CRB, from KRA. Remember what used to happen before. If you advertise for a job, you would ensure that you would, as part of the requirements, you would ask anybody who is interested to ensure that together with the application and their CV and their certificates, they provide these clearances. So this one also is now something we need to ensure that when we are conducting recruitments, then we are very aware. I know most of us maybe are familiar with this one, but it is important that now we ensure it is in our HR policies. Then we have the Tax Laws Amendment Act. What is fundamental is that the amendments have touched on Income Tax Act, the VAT Act, Miscellaneous Fees and Levies Act, and the Excise Duty Act on various issues. So for us, in terms of employment benefits, there's an expansion of the non-cash employment benefits in terms of taxation. So up from 36,000 per year to 60,000, all right? And then there's also, there was also an increase of tax-free meals for those organizations whereby they provide, or they have procured services of a person to provide meals, up to 60,000 from 48,000. And then also exemption on pension limits increased to 360,000 per annum. So these are things that we need to ensure that are reviewed, and we also train our staff so that when it comes to taxation, we are just not looking at the taxation that occur on the payslip, but we're also looking at the taxation that occurs post employment. Okay, and then as part of calculating the pensionable pay, no, not the pension, the tax, the taxable income. So contributions made under SHIF, contributions made under affordable housing, and contributions made to a post-retirement medical fund should be deducted first from the taxable income. All right. And then also the Act introduces tax exemptions on pension benefits upon retirement. All right. And then extends exemption to withdraw after 20 years up from the current 15 years. I know that is mouthful, we'll digest slowly, but what is important is to note that when you're calculating especially for the monthly, taxation, you should ensure that the amount that you're working as to deduct pay, then you have you have deducted the shift, you've deducted the affordable housing, and any contributions made to a post-retirement medical fund. And I want to believe that most of us, or some of us, have pushed or implemented the post-retirement medical fund. I know a lot of statistics indicate that, especially for those of us who work in the public service, after retirement, you're just one sickness away from either becoming bankrupt or dying, or actually even making your family bankrupt. So if we don't have post-retirement medical fund in our institutions, let's begin these conversations and ensure that our employees and their immediate families can benefit from post-retirement medical fund. That shows that you care for this person not only when they are actively in the employment space, but even when they retire. And remember, even you will retire, so very soon you'll be also on the other side. So it's good that we ensure we have policies that support our employees when they are on retirement. This one is on tax procedures amendments, and the issue here is that it mandates registration of employees working remotely outside Kenya for Kenyan employers. So if you have employees who are working outside Kenya and you are an organization or an institution based in Kenya, legally or otherwise, then you should ensure that those employees are registered with KRA. And of course, there's a fine for non-compliance on that. This one we are all aware about, the new one, Affordable Housing Act of 2024, which has introduced a mandatory contribution. And I know some of us, we still don't understand what it entails. So employees are supposed to contribute 1.5 of their gross salary, and then the employer is supposed to contribute 1.5 of their salary. This is a new one. We are all feeling the pinch. We need to understand that that is now law. And probably if there is a documentation or a procedure or a policy that talks about the taxes, then we need to, the taxes and the statutory deductions, then we need to ensure that we include the affordable housing deduction so that employees are aware. In addition to also sensitizing our employees on some of these statutory deductions. Then this one, I know we are also aware about it. We have made a lot of noise because Kenyans are saying it is not working. However, it is also in place. Actually, it's supposed to give effect to Article 43(1) of the Constitution, whereby the state is supposed to ensure that there's health for everybody as a fundamental right. So it establishes the Social Health Authority, and this replaces the National Health Insurance Fund. Yeah, and I know we are also aware about this particular change. Then we look at what is currently underway. These are bills. Bills, they transition to become acts when they have been assented into law. So we have one which has been going around for quite some time, since 2022. And this one proposes to prohibit employers from engaging, actually from contacting employees outside the official working hours, except under specified circumstances. All right, so it is still something that is, it's a proposal. We need to see whether it will see the light of day or not. But what this tells us is that we need also to be looking at it as employees. Remember, HR mainly we're supposed to be a go between our employers and the employees. So what would be the best practices? For instance, if you're to call Mercy at this time, this is around going to 6 p.m. Should I pick your call? Should I bluntly say no? What are the pros and cons? How can we promote a culture whereby we are not feeling constrained in terms of, working hours, but we have an open culture that is based on best interest for all of us. So that when I get a call from my boss past working hours, I understand it's not every day, it is for the benefit of the organization and maybe in return for my benefit as well. So, case for discussion there as HRs, we need to also think what are the best practices in terms of supporting that kind of an arrangement, because it could be inevitable in some situations, but it is also not very good, especially if it becomes the norm as opposed to it being an exception. All right, so then we have Labor Migration Management Bill, which aims to regulate private employment agencies. This would be very good, especially looking at the way these agencies engage in very unethical and professional ways of recruiting migrant workers, leading to violations of their rights. Sometimes they sign documents that they're not even aware, they're not represented, and because of the desperation of some of these brothers and sisters of ours, they end up getting into problems when they go abroad. So that would be a very good bill. We also need to look to be alive to it and ensure that as advisors of organizations and also as people who need to promote the welfare of our employees, then this is something that we should be able to adopt and run with it. The National Employment Authority Amendment Bill, it seeks to provide clear guidelines for deployment of Kenyan migrant workers, all right, including mandatory licensing of recruitment agencies and ensuring that we have a system on overseas Kenyan workers. Again, very useful for purposes of knowing who is out there, where are they working, and such other details that should be useful for protecting their rights wherever they are. So under core decisions, we'll be looking at 12 areas. We'll look at what have the courts said about data protection. Data protection is a new area, and it's getting all of us unawares. Data protection is really protected under the fundamental rights under privacy. So we need to understand what the Data Protection Act actually talks about. But
we should, because I have in mind several organizations that have been slammed with fines because of the very simple phone sharing ID.
Yes. So data protection. Remember, we are custodians of a lot of HR, a lot of employees' details. And how we manage that data, how we share, needs to be guided by the Data Protection Act. We need to understand what are the obligations of us as data managers and what are the rights of the data subjects who are our employees. Even the simple and mundane things that we do, like for instance, Richard, you have a physical training, you come up with a registration form, you tell us to sign. In that form, what else do you want about me and why? And where are you going to take that information? How are you going to preserve it so that nobody else has that information apart from you? Have I consented to giving you that information? And we also need to understand what is private data and what is even sensitive data. Data about my children, marital status, my religion, those ones are very, very sensitive. And should you be in custody or should you require that kind of information, then I need to understand why. And you also have an obligation to ensure that it is very, very well guarded. So issues to do with our databases, how safe are they? Can they be hacked? Because you're not going to court and say that this information, I don't know, was diverged by an intern, for instance, or it was, the responsibility lies squarely with you as an organization. Then we look at fraternization in the workplace, very interesting. Unilateral variation of employment contracts, constructive dismissal. We look at performance improvement plans. This one is usually in my heart of hearts. Anything performance management, I love performance management. Employee transfers, a very interesting case there. Handover and clearance. What are the new areas? What are the new issues? How about resignation? Probationary contracts, discharge agreements. What are those in the first place? Mutual separation and restrictive covenants. I believe once we have delved into some of this, we'll be having a good, this will form part of very good assignments for all of us. Yeah. You will even have a voice to go to your HR if you're not the head of HR, or if you're the head of HR, to go with a concept note on why you need to ensure that you review the HR policies. So let's look at each one of them one by one. We look at data protection. And as I have said, this one is wide. We need to understand data protection. Number one, it is fundamentally under the Constitution. Data protection is, I'm trying to look at Article 31, B and C of the Constitution. All right. And arising from that chapter, a law was enacted, Data Protection Act, which regulates the handling of personal data, including employment contexts, all those things that we ask about people, where did they go to school, their certificates and all that. So employers are required to ensure that they comply with the Act. And the case that we have here, the employer actually continued to use an image, yeah, in a marketing video after termination of an employee without their consent. Some of these things, you might find that it could be your communications department or your marketing department that are doing these things and they are not aware. Then before you know it, you are in court. Actually, not in court. The first place for the procedure for disputes concerning data protection, number one, they should be handled by the Office of the Data Protection Commissioner, or DPC. All right. And the court has settled that down, that before you go to court, and I hope you also understand some of these things so that you know where you should, which court or where do you begin in terms of dispute resolution. So yeah, so just for purposes of using personal image without consent, the complainant was awarded 500,000 shillings. And again, so that we all understand that should you find a matter, or should you hear somebody saying they have a matter in the ODPC and they are saying, or they are being told by law, lawyers can tell you everything. Yeah? They can tell you that they want to run to High Court. Believe me, they won't go far because they will be sent back. The lawyer will just have cooled your money, because by the time you go to a lawyer, we panic. So you go to a lawyer, they slap you with a bill. They tell you we have a very good case here, not knowing that, or we have a very good defense, not knowing that the High Court has already settled that before you go to any court, complaints under Data Protection Act must be addressed by the ODPC. So the jurisprudence here is consent. Yeah, consent. Before you use somebody's image, before you use somebody's contacts, before you use somebody's personal information, have they given you consent for that purpose? So you need to begin reviewing your processes, your procedures, and see where are you as an organization likely to be in breach of the Data Protection Act. And then after you look at those areas of risk, what do? You develop procedures, you train your employees. Yeah, you train your employees, because remember, it might not be you as a head or as a HR, it could be somebody. And as long as that person is your person, then I believe you'll suffer the consequences jointly and severally. So that's very critical for all of us. Consent.
Mercy, on what you have said, that point is very important. I recently discovered that if a watch person or a security person does the wrong thing, it is you, the organization, that will suffer the consequences. So you have that responsibility of training the people who are working in the organization to manage data. For example, if a security person gives the ID of a person to somebody else, the person who will be penalized, it is you. So the point that you have mentioned there, that it is good for you, especially when you outsource some services, it is important for you to inform them the consequences of data breach. So that is a very good point that I have not seen it occur in very many forums, and it's good you brought it up.
Thank you, Coach Richard. Yeah, so that's very true. You will bear the blame for the actions of commission or omission on behalf of your employees. Maybe I can just say, can give a few guidelines for processing personal data. I have talked about consent. There's also right to be informed, on anything regarding their personal data, whether you're collecting, whether you're using. Yeah, so right to be informed, that's very fundamental. Right to access personal data. Gone are the days when what you have in employees' file or systems is confidential. I have a right to know exactly what is in my personal record. And I also have a right to correct that information. So that one is a fundamental right. I also have a right for it to be deleted. Okay, if you hold some certain data, for instance, things to do with my private life. Maybe I had indicated that I was married to so and so, and now I want that record to be expunged. I have a right for that to be corrected as an employee. Right to object processing of my personal data for whatever reason, and right to data portability. Like I need to be made aware if you're going to be moving my data from point A to point B, and for why. So those are some of the principles when it comes to processing employee data, and we need to ensure that we get it right all the time. It's a new area. I know some of these things, like what Richard has given as an example, may seem trivial. Just sharing, and you have a book there. Hapo kwa gate yenu kwa ofisi. We all have that black book, and it's just normally left there. Yeah, not managed, not under lock and key, handed over by anyone. Anyone can peruse. You find people just there perusing. You don't know what they're perusing. That is a very serious. And by the way, it's not for small organizations, because most of our organizations, they use that old-fashioned way of keeping records of their employees or even visitors. So that's an area that we need to raise our voices and just ensure that we review the process of handling. Hiyo kitabu tu nakwanga imezeka pale na mtu na watch. It can put us in a lot of problems. Okay. So some of the things that maybe some of the tips that we can learn, maybe issues like access control, whether it's physical, whether it's manual records, whether it's the systems. As an organization, have you conducted, it's a high time you do an audit of access controls. If there are none, if they are weak, then we have some work to do. Data encryption, especially where you're sending messages or emails, so that you ensure that they cannot be hacked, they are end to end, and I don't know what that means by the way. Probably also have engagement with the telcos to understand. I think it's a high time we also get into understanding when they tell us that something is encrypted. Is it true? So that calls for probably then going out of your way to engage telcos, have conversations with Safaricom to start to exactly understand when I send a message through a code, in particular, maybe some codes here and there. Could I be breaching the act? Something else, maybe data protection by design and by default. By design and by default. You're very, very, very conscious that in every step of the way, in every procedure, you're conscious about data protection. So design systems that are, design systems ensure that that culture changes until it becomes like, automatic. Protection of the data that you have is mandatory. And then issues to do with maybe security of passwords. Some of us use passwords that are very weak. And by so doing, as employees, then we expose our organizations. So the issue of security of passwords, it's a high time we take it very, very seriously. Let's work with ICT to ensure that our employees understand why they need to protect their passwords. They need to have very strong passwords that cannot be hacked. Because again, if you find yourself on the other side and you need to prove that you're not on the wrong, that these are some of the things that you will have a very difficult time trying to explain to the court on what kind of measures, or how do you just explain that the system was hacked? What have you done as an employer? Then so many other things. I've talked about training, policies, very important, risk assessments under this field, very important, access logs, movement registers, and all that. All right, I think I've delved so much on that. You have quite a bit more of areas to look at, but it is important that we deal with that data protection because it is getting many of us, surprises. Then this one, fraternization in the workplace. I know we are aware about institutions, or some of us have even suffered, whereby you have relationships that are not official. You have intimate relationships between employees, all right? It has been very sensitive, especially in the private sector. And we know people who have either been told that, hey, now one of you have to decide whether you two go and decide who goes. Because here we don't allow people to have intimate relationships. But recently, there has been a landmark ruling. It is really landmark, very, very landmark, because I don't think we expected the court to support this. I know many of us expected the court to say, yes, there is no way I will allow people to start focusing on intimate relations. When will they work? However, the court has said that you cannot declare a blanket ban on employee relationships. Okay, it is very unconstitutional. Number one, you will be infringing on their right to privacy. You will also be infringing their right to dignity and also freedom from degrading treatment. And remember, the court is referencing actually the Constitution itself, Article 31, Article 28, Article 25. So what did the court advise? That while employers may regulate conduct, the word is regulate, okay? You cannot justify disciplinary action without evidence of workplace disruption. So if you don't have evidence, if these people just, and again, they are minding their own affairs after work hours, unless you can demonstrate that maybe there was that out of that relationship, then there was workplace disruption, then you have no business meddling into what people do in their private spaces. So that's very interesting as well. So we need to be aware. We need to train our employees. We need to be sensitive as well. Let's discuss some of these things openly. Yeah. And when we discuss openly with them, they will also understand how to draw boundaries. We guide them. And I say this because it's like for me, these are some of the things I would be looking at when I'm managing younger versions or younger people in the workplace. Because definitely if they come and they are single, what do you expect them to do? Where will they get spouses if not where they are spending most of their time? So the best thing is speak about it, guide them, coach them, mentor them. Those who have relationships or those who have found significant others within the same space, speak with them, hold the after all, you're the HR. Hold their hands, tell them the do's and the don'ts. And I believe if we take that approach, then it shouldn't be a big deal. But again, I know it's not easy. Any comments? You can be throwing comments on the chat. I would love to hear experiences. I would love to hear stories related to some of these things that we are discussing. Is there anyone who wants to say something? Richard, maybe you can assist me by looking at the chat.
Yeah. Any experience, any thought processes? Victor, we can hear you.
All right, let's proceed. Feel free to put anything on the chat. We can review those later. Then on performance improvement plans. This is an issue of managing performance. All right. And I know performance management is something that has been evolving. Sometimes we get it right, sometimes we get it wrong. Sometimes I know we are familiar with errors in performance appraisals, and we have either suffered or we have been the perpetrators of those errors. So that we look at performance management just on the basis of the appraisal, all right? On the basis of the appraisal, and the appraisal sometimes is informed by many things. It could be informed by biases, or it could be informed by what has happened in the recent past, so that if the last 1 week I did not meet a particular target during the appraisal, you appraise me negatively, and many other errors. So the court, in this particular case, found that the termination, because this employee was terminated on the basis of performance, the termination of an employee was unjust, and it held that an employer must first address and discuss performance concerns with the employee before considering dismissal. When it comes to performance management, I think the court is very intentional. It is not business as usual. The onus of, or the responsibility to prove in this case rests with the employer. So you must demonstrate what exactly you're saying when you're saying, what exactly are you saying when you're saying, I hope I'm speaking in English. Unasema nini ukweli? When you say that you're dismissing this particular person on account of non-performance. So number one, there has to be the issue of support. All right, support in terms of training. Remember, I could be unable to perform because I need some training. I lack skills. I lack competencies in that particular field. But oftentimes employers are not able to meet that gap. So I will continue to suffer in the hands of the employer, yet they have a responsibility to support me in terms of training. Then defined standards. I don't know whether all of us are very clear on how to set targets and how should the targets be set. They should be smart, specific, measurable, achievable, realistic, timely, but all those aspects of standards must be very clear. They should be discussed with the employee, you know. There should be communication, and it's continuous communication from when the performance period commences to the end. You should be able to demonstrate that you have been working and communicating with these employees. You have been giving them support. Don't surprise them the last minute, and in a HR committee decide that now this one we are firing them, and the reason is lack of performance. So that's another very critical area. And remember, you employ an employee, you onboard somebody, you recruit somebody and get them so that they can perform. So when they're not performing, you also have a responsibility of analyzing what is it that this person is struggling with, and then support them. Unless it is and then of course there are those that are, you know, unfortunately, they cannot be assisted, or it becomes now a case that now here we have to part ways. However, remember that documentation is critical on what you as an employer has been doing to support his employee. All right. Then we look at variation of employment contracts and constructive dismissal. And the law is very, very clear, especially on termination and dismissal. And one of the principles is that for any terms to be varied, it has to be mutual. There has to be mutual consent. So in a recent landmark decision, the Supreme Court actually, this is a Supreme Court matter, so this one is final. This is supreme law. It held that unilateral variation of employment terms, particularly those not communicated or agreed upon, will be or may be deemed as repudiatory breach. Repudiatory is that they are so grave in nature, all right? And where they lead to termination, it may amount to constructive dismissal, okay? So failure to inform or consult the employee on such changes constitutes an unfair labor practice. So should there be need to vary employment contract or clauses for one reason or the other, then there has to be with the consent of the employee, all right? And sometimes because of the employer always has an upper hand. And that is why I think the courts are very, very, very intentional to support employees. Sometimes the terms are varied so drastically in such a manner that the employee is left with no other option than to resign. So if the employee resigns under those circumstances and goes to court and demonstrates that the reason for them resigning was actually because of the variation in terms, then you as the employer will be the one who will have lost the matter. Okay, balancing employee transfers and family welfare. This one is also very, very, very critical. Transfers, we have a transfer policy that, especially those of us in government, that as long as the employer has offices all over the country or wherever, you are at liberty to transfer employees. However, in a recent ruling, the issue of family welfare has come up, and I think there's nothing as impressive as this. Especially, unfortunately, we're the haters. We're the ones who transfer people away from their families. And again, for some of us, family is everything. So it's a delicate balance. So what happened in this particular case? An employee was actually a police officer was transferred. Yeah, and the basis for him going to court was that he was transferred. He tried to argue his case on the basis of having a child who is abled differently, but the employer could not listen to that. So he went to court. Yeah. And the court ruled in their favor, emphasizing the obligation of employers to prevent discrimination and unfair treatment based on family responsibilities. While we're talking about unfair treatment, we need to look at the rights especially of children and our vulnerable groups. Okay, so that because they're protected in law. So when you're implementing some of these decisions, and when you see your organizations implementing some of these decisions, then you need to caution them, because they might be taken to court, and already the court has set a precedent in terms of infringing of constitutional rights, especially of children, persons living with disabilities, and vulnerable groups in our communities. So let's champion family welfare. I think this one and the one for fraternization is really, really a new area for us. And what I would say is that as HR, we need to look at how else can we support our employees to both deal with the work and also be there for their families, especially their children. Okay, so we look at handover and clearance, and then this is a question of terminal dues after resignation. So what happened is that the employer withheld payment of payment of the dues to this particular employee, arguing that he needed to have finalized the clearance process, and the court ruled that the claimant's demand was premature. So it is okay, especially knowing that sometimes an employee could resign, right? And most of employees resign, but when you go to the clearance process, especially in accounts and everything, there's a bit of gap. Ajamaliza, kuna mahali akona gap. So the court there again supports employers, saying that the clearance process is very, very critical, right? So take home there is HR policies requiring a clearance prior to the disbursement of terminal dues are legally permissible and do not contravene employment law. So we can ensure that we are not also we are not what would I say? Sometimes when employees when they resign, they can be so hard on us. There's emergency, there's now you're mistreating me. We need to balance both. So the process, just explain to them that this is part of our processes. Ensure that you clear with us, bring us all the documents or the surrenders that are necessary, then we'll be able to fast track payment of your terminal dues. I know it can be a bit of pressure, especially because somebody has already decided that they want to leave the organization. So in that regard, we do not contravene employment laws by emphasizing on the clearance and handover procedures. Resignation, this one is the opposite. So under section 35 and 36 of the Employment Act, an employee may terminate the employment, and we all know that the notice is 1 month. Yeah. For those of us who work for a month, or again, depending on how the contract is, but for most of us, it is a month. So an employee can give a notice or pay in lieu of notice. And in this particular case, the court held that an employee's resignation is valid upon submission of the resignation letter. Okay. I know we have seen instances whereby you're told your resignation letter is going through some processes of validation, I don't know, approval and all that. So what the court held here is that when a resignation letter has been placed on your desk, regardless of whether you accept it or not, that resignation is valid, as long as it has been submitted within the notice period timelines or together with payment in lieu of notice. So, and the right here is under Article 30, which says that, let me look at what Article 30 says so that I don't mislead us. What does it exactly say? Actually, it is very severe. Contravention of Article 30 is under slavery, servitude, and forced labor. So the moment you're saying that you're not accepting a resignation, it shows that you want this person to continue working for you as a forced labor or slavery or under servitude. So a person shall not be held in slavery or servitude. And number two, a person shall not be required to perform forced labor. Okay. So employers who attempt to reject an employee's resignation may face legal ramifications, including claims of unlawful restraint of personal liberty. So this is a new area, okay, that we need to ensure that we advise appropriately. On probationary contracts, a very interesting perspective here. And what this particular matter was about is that the court held that under Section 42 of the Employment Act, the law does not require employers to provide reasons for extending probation, provided the employee consents. All right. So should you want to, that is one aspect of a probationary contract. Should you want to extend the period for probation, you can, but however, there has to be the consent of the employee. Okay. And then secondly, in the second case, Mutua versus Seafowl Motors, you cannot now apply probation to employees who have been serving beyond the probationary period. If the probation period is for 6 months and you want now, after working for 2 years, you want to start putting me again under probationary terms, then that one cannot hold. It contravenes fair labor practices. So to align with this, what is the HR required to do? To ensure that you clearly define the terms of probation in the employment contracts, including duration and performance expectations. So an extension, not after you have now changed my terms from probation to maybe permanent and pensionable. An extension after the expiry of the probationary period must be accompanied by a consent, and not preferably, it should be in writing. Okay. And organizations should avoid reinstating probationary terms for long-serving employees. Discharge agreements. This is a settlement signed upon employment termination, whereby the employer agrees to pay all dues and the employee waives future claims related to the employment. I know we have seen most of the organizations going this way, so that as part of the discharge agreement, I am saying that I will pay you this as final, and I sign there, acknowledging that I have received all the final dues. But when I go out there, I realize or I'm advised otherwise. Okay. So we have said that before the court questioned such agreements due to their unequal power dynamics in employment. This is a fact. And in this particular case, which is very recent, 2024, the court upheld the discharge agreements where they are entered into voluntarily and with full knowledge. So for us as HR is to ensure that discharge agreements are clear, fair, and signed voluntarily. We should also encourage access to legal advice, document informed consent, and train HR staff on how to draft, and also sensitize our employees as well, so that we are not seen like we are exercising our power as employers on this side of the employer to the detriment of the employees. So regularly reviewing termination procedures will help maintain compliance and protect both the employer and employee. So the issue of discharge agreements has been settled in courts. It is asked to ensure that we align our policies, we train our staff, we sensitize our staff so that they understand where we are coming from. And when it comes to signing those agreements, then let the environment, or let us demonstrate that we are using fair labor practices. The person has been given notice, you have been allowed to consult. It's not that you have been called this morning and you're told, sign up ama tutakulipa pesa yenye itabaki. Alafu that person wakes up one day and realizes, apana, you never know. When they go to court and they demonstrate that it was not fair, there was no fair administrative procedure that was that can be demonstrated during that time, then I think we will be losing as HR. Mutual separation. All right. So here, an employee and an employer mutually agree to terminate the employment relationship, and these agreements serve as effective tools for avoiding doubts, avoiding disputes. So what the courts held is that even if we have mutual separation agreements, they cannot override legal safeguards, all right, under Section 40 of the Employment Act. And the court held that terminal dues agreed upon must still conform to statutory reduction provisions and the terms of the employment contract. So here we are signing an agreement. However, it must be lawful. It it must be guided by the contractual obligations for both of us as an employer and as an employee. So in this particular case, the court again upheld the validity of an MSA, ruling that a party who voluntarily participated in its negotiation and accepted its benefits could not later dispute their termination. All right. So HR policy should incorporate clear procedures again to ensure fairness, transparency, and participation of the employee. Then we must also align the MSAs with statutory and contractual obligations. Ensure that you look at the everything as a package. You look at your policies, you look at the employment letters, and then you ensure that whatever is provided for in those policy documents are part of your agreement. And I think what some of these areas are showing is that we could be managing the HR processes very well, especially recruitment, onboarding, in between, until it comes to separation. Separation, I think that is where we are seeing many people have gone to court, and the court has been able to resolve these issues very, very, very clearly. Restrictive covenants, again, agreements aimed at ensuring that employees are limited, especially during employment or after employment. The Kenyan courts enforce these covenants only if they are reasonable in scope, time, and geography. So the court upheld that such restrictions, provided they protect genuine business interests, all right, do not limit employees' ability to use their acquired skills. Here, the question is, I'm signing a restrictive covenant, not maybe to do certain things while I'm your employee or when I leave. So what the court has said is that employers must adhere to ensuring that there's a balance between protecting the interests of the business and ensuring fairness. Ensuring fairness on the part of the employee being able to use their acquired skills. So that is also another very new area of law. We need to look at it. We need to give it some more time to look at how can we craft a policy around that area, especially where we are operating in an environment of competition with other institutions, and also ensure that the interests and welfare of employees are safeguarded. So we are done. That was the last issue. And what are some of the recommendations that we can come up with out of this presentation? Number one, the need to periodically review policies and procedures. Sometimes we just use procedures that were developed a long time ago, and we are very conscious, we are aware of the changes that have happened. But the question is, have we taken time to review these policies and procedures? Remember, your policy and procedures is a management tool. It is a tool that helps you as a HR to, number one, train even the leadership of the organization. Yeah, you train them on how to manage the employment workforce. They are tools for decision making. They are tools for fairness and consistency and transparency, because something that is in the policy that has been shared, disseminated, it is there out there. So it is a tool for ensuring that everybody in the organization uses or is consistent in the way they handle employees. And most importantly, it promotes a culture of, openness, transparent. People feel empowered. Even your managers, even your employees, they feel empowered because they can go to the policy quickly and just see what are the provisions, and that way they'll be able to operate seamlessly without difficulties. But if you don't have policies, or you have policies that are not known, number one, you have procedures that are archaic, then you will have a problem. So HR department should ensure that we assist organizations to periodically review policies. And I think often, I would say maybe between 2 to 3 years, that should be time for you to take your policy, subject it to scrutiny, to review, to an audit, and then initiate a review of the same. Then training, very important for all HR professionals and management on emerging legal changes, compliance obligations, and employee rights. There's need for training, especially on employment provisions. What are the what are the employees' rights? What are the obligations, statutory obligations for the employer? And this is something that we need to ensure that we constantly appraise our management and staff on, so that we understand how to ensure that there's compliance, both for the employee, what are the expectations, and for the employer. So training around employment and labor laws, and especially changes in what is going on. I don't know how many of us have taken our staff through, like, for instance, the question of data protection. That is very critical. We need to work with people who understand the Data Protection Act and ensure that we train our staff continuously, including that watchman there, including that tea girl there, because you never know the kind of information they hold and what they will use it against an employee, and that could land us in problems. Then design policies that are flexible and can be easily updated as law changes without disrupting workflow or morale. Remember, policies are supposed to be broad guidelines. So some of us prescribe policies that are too detailed until they're too prescriptive. A policy should be broad enough. It should give room for flexibility without disrupting workflow or morale. So you can actually, we say that a policy should be broad enough. Like I would have used that example, but it doesn't seem very right. Like a miniskirt, yeah, long enough to hide the subject matter, but also short enough to elicit, attention. That's an old example that I'm using. But it should just be reasonable. Give reasonable provisions, but don't be too prescriptive. When it comes to prescription, then you can now leave those to, you can have those under procedures, or you can leave those for management decision. Okay. Most importantly, number 4, I know as HR, there's a lot of by the way, the practice of HR is purely and mostly legal, because it is, you can see, we have the Constitution with us. We have all those laws, the 5 laws that govern the practice of HR. We have the court decisions. So there's a lot of research that goes into informing the policies, that goes into training our staff or training ourselves. So we need to partner with law experts or legal firms to receive guidance and stay ahead of anticipated reforms. So I know we don't have, speaking for my own organization, we do not have like a legal department within HR, or even where we'll have legal departments, I doubt whether we actively engage our colleagues in the legal space. It is the high time that we forge strong partnerships with people in the law, in the legal field, to ensure that we receive guidance, especially when it comes to HR matters. Okay. Then open communication channels. We have seen a lot of misunderstandings as we're going through the areas of law, either due to when managing, for instance, an example that I would give is the performance management process. When there's no open communication channels, how do you expect that you're able to discuss performance of an employee with an aim to support, with an aim to sharpen maybe the targets, with an aim to mentor them or attach them to a person who understands that particular role better? So open communication, even when it comes to termination of employee, at the end when you need to part ways, when it comes to personal issues. We've talked about fraternization or having personal relationships at the workplace. Let's maintain open communication channels with our employees. As part of this presentation, there was a question of whether the current labor laws could be overturned by various governments, but maybe the government that could come. And what I would say is that we have a very progressive constitution, which is very firm about many rights of citizens, including employees. So again, regardless of the government that comes, it will be very difficult for them to come and begin introducing unfair labor practices, or maybe challenging the right to the freedom of association as an employee by either joining a trade union or by maybe an employer joining an employers association and stuff like that. So under the Constitution and under the current Employment Act, without even looking at other areas, there are sufficient safeguards to protect employees from unfair labor practices, okay? Then we are saying that maybe should there be need, then it will have to go the long haul, start with public participation, and Kenyans have become very enlightened. We have a very enlightened Gen Z as well. So anything that maybe will be anything that will be proposed to amend the existing laws will not be easy. Even if there will be need to amend, it could be only for the benefit of the employee, as we have seen. The recent amendments are actually to support the employees. And should there be anything else, then it will not be easy, because public participation ahead of the enactment of that particular law will be it will be a lot. It will be quite challenging with the current citizenry that we have in the country. So we are saying that a future government with a strong parliamentary majority, or even specific economic goals such as boosting investment or addressing the unemployment, they push for reforms that increase labor market flexibility, including relaxed termination rules or expanded use of short-term contracts. Yeah, so again, depending on the focus of a government, we could see, like for instance, the current government has been able to push some of these taxes, like the housing, the affordable housing, because number one, it is in the constitution. It is only that maybe the way it was implemented is what the Kenyans could be contesting. So depending on what their economic goals are, we may not say that we are not expecting changes, but the fundamental principle is that the changes should be or must be aligned to the interests of the employees. What I have said there in conclusion is that past attempts to dilute labor laws have often been blocked due to public backlash or legal challenges, and I think that one is very, very, very alive to us. In conclusion, these emerging issues underscore the dynamic nature of the modern workplace. The modern workplace is very, very dynamic. We have not captured everything in the current dynamic modern workforce, because our focus for this presentation was on the new legislative changes. There are many, many, many other dynamics, very, very many, so many other things, some of which we have heard about, some of which are still conversations. We still have issues to do with, for instance, remote working, which are still hanging in the balance. We have now AI that is with us. How are we prepared to use AI? The gig economy, whereby you have an employee dealing with several employers, and the rationale is, I am interested in giving you give me your targets. When I deliver, don't ask me, so that I give you your work, leave me alone. The rest of the time I can deal with other employers. So there are a lot of dynamics in the nature of the modern workplace. Balancing intergeneration workforces are also very issues that are alive with us. So there are all these things that we need to be alive to as HR practitioners, and there's need for continued learning and relearning. As organizations navigate the complexities of the legal landscape, adapting to these shifts, it would be very, very critical for us to adapt to ensure that we continue delivering on our goals and objectives. And by embracing these dynamic changes, businesses can position themselves to thrive in the transformative era of hard work. And that is the end of my presentation. I am ready for comments and questions. We can have plenary and we see how that goes. Alongside that, I think I will also take some time to respond to the questions that had been shared in advance. I could do a water break as I look at those questions first, and then we look at the rest of the comments and questions. Over to you, moderator coach Richard, for the next session.
Thank you very much, Mercy Mwirigi. You have done a commendable job in bringing us new case laws and instances where the law that regulates labor and employment in Kenya, we have learned quite a bit that is going to save ourselves from embarrassment and also save employers from getting into litigation spaces. Thank you so much. That was a wonderful presentation. That was well done. Now, ladies and gentlemen, we can ask questions. Also, we can unmute and add to what Mercy has just told us. You're free to unmute, and as a person who trains public speaking, I always encourage people to just learn to get into opportunities like this and the practice, so that that fear that you have and it is constraining you, it will disappear. This is the moment for you to shine as we go into the long holiday. Jacqueline, what have you learned? Rhoda, Hillary, what have you learned? Rola was one of the first people to get into this discussion. Thank you very much. Juliana, Milton, Tyson, what have you learned? You can either add to the chat or you can unmute and say something that you have just discovered today, and it's going to be beneficial to you. Mugira, thank you so much for making time to attend. What have you learned today?
Thank you very much, Richard and Mercy. That was very insightful, especially on the data protection part, which is a bit scary, and I feel like I still have a lot to learn. You talked about the use of images for staff, and in our organization, we've, especially now that many staff are exiting, and we've been using staff images in our brochures and IC materials. I don't know how that could be a breach. If that is a breach, if maybe a staff has left and we still have these IC materials out there, I don't know if that also constitutes to a breach of the act. Thank you.
Mercy, there you go. Your first question.
Thank you very much for throwing the first question. I expected it, and I can tell you for a fact, if you feel you're behind in terms of appraising yourself with Data Protection Act, that is a very good space. You're better than majority of us who may not confess that. So what I would encourage you to do is just ensure that you just go through the data protection, just even by taking the act itself and going through, you'll be able to understand a lot. But also, if you need help, we can assist you in looking at the options. How can you get a facilitator to train you and train your employees or even train the management in that regard? The question of using images of staff, especially when they have left, I've given the case that we cited was for an employee who had actually left. So you will be infringing on their rights. So it is better you reach out to them, maybe have a consent signed, again, depending on how your separation procedures are. These are things that we must address, because if this person goes to court, imagine you're going to lose. So look at ways of either reaching out to that particular employee, let them consent, or just redesign other IC materials. And maybe what could be safer is to use copyrighted images. Moving forward, we might stop using real images, because what happens when we leave and we say, no, I don't want my brochure, my image to be used in this particular organization, because they already left. Yeah, I don't know that I have answered your question, but the issue of consent is very important. Actually, the mere assumption that I want my image out there may not hold water anymore. What we could do is, as part of our routines, as part of our procedures as an organization, let's agree, when do we ask for consent from our employees and on what areas? Borrowing from what I'm seeing recently with my schools, my child's school. Always if there's something, they come with a form, I sign. A form, naenda sijui wapi, I sign. A form that is images could be used maybe from a swimming gala competition in the school things, I sign. So that tells you that organizations are becoming alive to the need for consent from their employees. It's better to be safe than to be sorry. And because you're aware, just go and look at how can you institutionalize that bit of employees consenting for use of their, remember, it's personal. My image is personal. All right. I hope I have answered your question.
Yes, thank you very much.
You're welcome.
I can buttress what you have just said. Yes, you will be sued and you will have to pay upwards of 500,000 for using somebody's image without consent, first and foremost. Secondly, the contract you have with that person can be terminated. They can terminate that relationship that you're using their image. In fact, the case, Mwangi Kuria, a former University of Nairobi student who sued the University of Kabianga for using his graduation photo without consent. The university was fined 500,000. Then there is another similar case which had occurred early August 2022 when Catherine Njeri sued the University of Machakos for using her photo in advertisement without a consent. That is consent. She was given damages of 700,000. So these days, it is very, very precarious for you to use anything, any data for a person without their consent. And you should have a lawyer draw a very good agreement with a person, how long are you going to have the image, under what conditions, so that a person cannot come back and say, I didn't give back consent, or even if I gave consent, I think it should come to an end. So you have got to really, as Mercy has told us, we have got to collaborate with the wakili so that we can be able to be on the safe side instead of losing 700,000, which can be used in buying birthday cakes for those people who believe in employee engagement. Over to you, Mercy. Any other question?
No, thank you. I'm just also thinking around the participants lists and the visitors books and all the information that people leave behind for us. That's also a risk, right?
A
Mercy,
big
over to
one.
you.
Oh, big one, a 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 big one. Information about there's my personal data, you know, my name, my telephone number, my email address. That is sensitive. And recently, you have seen even how people are being conned, or people are being, you know, you get information about where my child goes to school, and then you go to that school and you hide, you know, a lot of things, especially now that Kenyans, what do they call it? We are able to understand, to learn so much about you based on the personal data that is out there. So you'll get information about Mercy maybe from somebody, and unfortunately, if it is from the employer, that now will be terrible. You get information about the name of my children, yeah, and using the name of the children, you can be able to find out where they go to school and probably you do other things. So there's a lot of that is why personal data is protected. So when you're designing a register for whatever nature, ensure that you have thought about the access controls, and there's consent, and there's consent from the person who's giving you that information. They understand why they're giving you that information, and you as the person collecting that information, once you use it for the right purpose, and beyond that purpose forget, then ensure that you have access, you have thought about disposal of that information. Once those attendance registers that you sign, where are they? Who keeps them? For what purpose? Who has custody of them? When will they be disposed? It was a conference that was held in 2021. You still have attendance registers lying all over the place with people's personal information. Yeah, so where you feel there's a risk, then tighten that risk. You'd rather even have information maybe electronically submitted in a system that is a bit secure.
Actually, that is why nowadays you see on CVs people write upon request, because you do not want Richard's number, for example, in your CV, and it is shared in like 20 WhatsApp groups. So that is why people are very hesitant in putting their referees on their CVs, especially when they plan to share it in multiple platforms.
All right. Thank you so much. Thank you.
Thank you. Maybe we can look at the chat and see the questions that are there. I see one from, thank you, Ms. Faraja. I think we have handled yours. I can see Victor was asking a question on where do we place the question of an organization asking for declaration of conflict of interest when one is in an intimate relationship with another employee. Could that be a breach of privacy? The answer is a resounding yes. You have no business mending into people's private affairs.
We were functioning under ignorance. Nobody had ever challenged that until that guy of G4S.
Until that guy of G4S, yeah. And actually, it is constitutionally wrong. Every person has a right to privacy, including the right not to have, I will leave A and B, I go to C, information relating to their family or private affairs unnecessarily required or revealed. Private affairs are private affairs. So declaration, there's no conflict of interest at all. You use your own mechanisms to ensure that employees, you know, unless you can tell that now this one is bordering into, it's affecting the workspace in ways that you can explain, better than just assuming that because this one is in a relationship with the other one, there's a problem. There's no problem. That's a private space. All right.
In addition to what you have said, Mercy, I recently learned, you know, HR, sometimes we can be very enthusiastic, or supervisors or heads of department. They want to see, I want to see where you are sick. I want to see where I want to see your disease. Imagine it is illegal to want to read somebody's sickness unless it is necessary. It is illegal for you to have the information. If the doctor says this person requires 3 days and that doctor is a registered doctor, don't dare ask what type of disease that person is suffering from. Surprise, surprise. Over to you, Mercy.
Yes, thank you, Richard, for buttressing on that. Details about somebody's health, those are not only private, but they are also very, 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 very sensitive. And you will be in contravention of the law by trying to go into that space. There's a question on pre-adoptive leave. At what stage of adoption process does the leave apply, or is it open to the parties? I think it is, the provision is that the person who requires that leave should give at least 2 weeks before the adoption, and they're entitled to 1 month. So before you give notice 2 weeks in advance, because again, yeah, that is, I think, what the law says, but we have some lawyers in the house. Milton, if you're on the call, maybe you can assist in clarifying this, but that is my understanding. And then the stage of adoption, I believe it is to support, just like the way you cannot take maternity or paternity leave outside the maternity leave period. I want to believe that also the adoptive leave should be at the onset, at the early stage, so that you take your 1 month as soon as the adoption begins. But we have Milton, if you're able to admit, maybe you can speak at the end. There's a question on Tyson. What happens when a manager or a supervisor is involved with an intern? Should this be allowed because they are doing it out of office? What about if this is affecting the performance? Now, this is where the trick is. This is where the catch is. Yeah. How do you demonstrate that it is affecting performance? Otherwise, it's just for the sake of it. Then that is a private. These are adults, consenting adults. Privacy again into what they do. That's not your business, unless you can demonstrate that it is affecting performance. And remember, this is what we are talking about. Open door policy, communication. Speak with these interns as well, because I know for the intern it may not be just a question of intimacy, but speak to them as a profession. How does it align with their long-term goals, either as human beings or as professionals? But in terms of what is going on, that one is not our space. Unless now these are a bit of just general counseling and mentorship for the interns, but they would not be contravening any law by having private relationship with anybody, including the supervisor or the manager. Train your managers and train your supervisors to have mercy on interns. When they buy the mandazi and tea, it should just for purposes of supporting them, not for purposes of anything else. I hope I've answered that. Then contracting employees out of work hours. Does the bill address or shall it include contracting? Actually, it was contacting outside work hours. Let me read the question. Does it include contacting them while on leave? Or what is the guide when one is on leave? And contacting on office matters. Should one be called, recalled, or employer should wait for leave to end? Is it to communicate information that is urgent, adverse, impacting employment status? The bill is still a bill. I believe it will be clarified exactly what the law will be saying. But the issue is actually in support of work-life integration or work-life balance. What I would say about leave is that employees should be allowed to go on leave. It is upon us to ensure that work continues when somebody is on leave. So ensure that we train We train, we have proper succession management, succession planning, training, mentorship, and coaching, so that when I take my leave, I am allowed to go on leave. However, nothing prohibits, in an environment, again, it depends. It depends on the culture that we have as an organization. What culture do we have? Do we have a culture whereby I see Hillary as my supervisor calling me when I'm on leave, and I will not pick that call because ni kusumbua tu, or I will see Hillary's call and respond because it could be either an issue of emergency or it could be a clarification. So there's that, an open culture where employee don't feel like, they're just being mishandled or mistreated. But legally, if you're on leave, you are on leave. Nobody will take you to court for not having performed duties, whereas you are on leave. And leave, again, is a provision in the law. Allow employees to go on leave. Yes, Richard.
Actually, Mercy, what the employment law says, Employment Act 2007 says, uninterrupted first 14 days. Uninterrupted. Those are the words. So which means if you don't receive, we are not saying that you become belligerent, but we are saying what the law says. So it is up to your discretion. The law says 14 uninterrupted days for leave. So actually, when the bill becomes law, if it doesn't get roadblocks, because manufacturers and business people might block it, because our parliament is our parliament, it will protect you from working when you are on leave, which beats the logic of you having gone on leave. Because psychologists say that it takes around 14 days for you to get out of work that you have been. There is a psychological research that says that it takes around 14 days for you to really now start relaxing. Otherwise, the first 14 days, your mind is still processing things that you need around 14 days for you to get out of that work environment, which is the essential thing here. Over to you, Mercy.
So that is clear. Leave is legal and lawful. And when you're on leave, you're not on duty. I don't know whether there's anybody who wanted to speak. Milton, are you able to speak?
I hope you can hear me.
Yes, you're very loud and clear. Go ahead.
Thank you for having me this evening. Mercy, that was quite a commendable presentation. There was mastery of content, and that was good. Now, I wanted to speak on the issue to do with data protection first. Whether or not the employee is excited to be, there is need to. The most important thing is consent. To have their data out there, their images, their sensitive personal data, we have to have the consent of the employee or any person that you're handling their data, so that to avoid any disputes with the Office of the Data Protection Commissioner. Number two, I wanted to speak on the issue of fraternization in the workplace. What that case has done, it has unconstitutionalized the blanket ban. So when we're drafting the policies on fraternization, I saw a question on declaration. The declaration is very important due for conflict of interest, so that when HR is drafting these policies, you ensure there's no conflict of interest. Let's say the person involved, one is in a higher hierarchy in terms of the organizational chart. So to avoid such conflict of interest, there's need for declaration, so to avoid favorism in the workplace. And then so the blanket ban itself is what is not allowed, but the policy should not ban romantic relationships in the workplace, but declaration is important to avoid favoritism or any inconveniences that may, your romantic relationship should not affect other employees, because we are human beings and we are coined towards favoring those we are in cordial relationships or romantic relationships with. Number 3, I saw a question on when does the pre-adoptive leave occur. When you look at Section 29A of the Employment Act, it begins from the date of the placement of the child. So you can take it from the date it officially begins. You can be granted leave from the date of the placement of the child. I don't think I have any else to say, unless you have questions for me. Thank you so much.
Okay, so thank you. That is a partnership between HR and law. Milton is an advocate of the High Court, and Milton, because you're still young and very promising, you could share your contact here. I know some of us may not have an advocate they can run to, and by the powers bestowed upon me, I allow the participants today to get free legal advice from you for the next 3 months. Especially on this particular topic. Milton, share your contact with the permission of Richie. And we encourage you to continue being a friend of others HR. So I think you have said the issue is very correct. The question of adoptive leave, we are clear. When does it begin? The question of declaration, you have also advised that there's nothing wrong with people declaring. But now, if you declare and I go sharing that you have declared, surely, see, that is now infringement of private data. Or this is now for management again and again. How we manage that information should be guided by the Data Protection Act. Very interesting. Let's hear views from the floor on declaring conflict of interest. And when do you declare? When do you declare? Because these things just, they happen. So when will you require me to declare, Milton, that there's something that is cooking?
First of all, conflict, there's a very thin line here with regards to privacy and conflict of interest. One, we agree, yes, this is data that is very sensitive. It's sensitive personal data, but it's important for an organization in such, especially with senior employees getting involved in romantic relationships with junior employees, and where the decision making is altered, then there's need, because it might be a ground for also termination, where there's favorism of other employees over others. So there's a very thin balance, but I think declaring and then how that data will be used is what will determine whether it's an infringement or not. I don't think whether I think I'm clear on that. Any follow-up question? Are you getting me?
Yeah, we are getting you. I see Victor's hand is up. Let's hear Victor.
Yeah, a follow-up on just that. Now that there are companies which also have policies on the diversity, inclusion, and equity. Will that not be a breach of diversity, inclusion, and equity if maybe there was a manager who favors their subordinates in regards to how they relate? So will we not? Is it not enough to place that as a breach of the diversity, inclusivity, and equity policy? Yeah.
Thank you, Victor. I think that is correct. However, what the court guided is that the blanket condemnation, blanket ban of workplace relationships is what the court is against. However, if there is evidence or indication that they are going to affect the workplace, for instance, by what your raising, then that is an issue. But blanket is what the court is against. But if there's no issue at all, we are not seeing favoritism between the senior employer and the junior employer vis-a-vis the rest of the senior employee and a junior employee compared to the colleagues in that level, then there is no issue. I hope we are clear.
Yeah, we are clear. One more.
Yes, Victor.
As you are addressing the data protection question, it's very interesting that actually companies should also be training people or outsourced companies. Suppose there is a task that needs outsourcing, then they should be training also the contracted companies on certain matters. Specifically, one that I had is on data protection. Now, my question was, there are this is like for security reasons or security tasks, companies always outsource security firms, and they do collect personal information. In most cases, they don't explain to you what they are going to do with with your information. So it means you don't have time to give consent whether you accept them to take all that information. Now, in cases where this
Did Victor drop, or I'm the one who dropped?
No, I think he has dropped.
Oh, sorry.
Okay.
I now the question was, in case where the security firm messes with the information that they have received from people who are in relation to this organization, is the organization accountable, or the security firm which was outsourced accountable? Because I believe they also have their policies on data protection.
Let me answer that. One, we have Article 31 of the Constitution, which provides on the right to privacy. First of all, if is what we call limitation of rights, and here the right of privacy and accessing such buildings is normally limited for security reasons. We only have 5 non-derogable rights which cannot be limited, but rights such as privacy, a right to privacy, can be limited. Now, when accessing a building, due to security threats, there's need to collect your information, and then so therefore the right is normally limited at that point. Now, where that is what we call a contract for service. Yes, these are independent contractors, but they are actually doing the work for the organization. So they're independent, but they are not liable for whatever grave mistake they may do. So in such a case where the security personnel mess up with whatever information they collect, you as the organization that contracted that security firm is the one that is liable. And then that's why Mercy, in her recommendations, she said there's need to control the access of this data that is normally collected.
Well, thank you. That's clear.
Thank you, Milton, for responding to that very, very clearly. I heard you talking about 5 rights that cannot be limited. Maybe on the chat you can let us know which one those are as a bonus for our participants this evening. On the chat you can quickly put those as we enjoy your free legal advice and support. I'm seeing a question from, yes, Miss Faraja, your hand is up. I was about to read your question. Please go.
Okay. Before that one, I'm also curious. You mentioned about something around favoritism. If the relationship results to favoritism, maybe some guidance on how one can justify there is favoritism happening. Just like you also shared, it would not be so easy to say that someone is not performing as a result of that relationship. Maybe some wisdom on that. Thank you.
You know, for HR, our operations must be guided by policies, number one, for procedures, number two, communication, possibly written communication, and records. So those things must go hand in hand. So policy, procedures, communications on everything, including performance standards. And also whereby there is now something like an allegation. It cannot be an allegation. There has to be a complaint, maybe, for instance, either from an employee. There could be a letter addressed to the employee, and it should be dealt with within the provisions of the law when it comes to handling a dispute. Remember that it cannot be a hearsay. It has to be something that has been documented. So document the complaint or the issue by raising it up with the employee, and there are provisions on how you go about that in the Employment Act or in the respective HR policy. What is important is a right for the other person to respond, fairness, hearing, and a due process, so that whatever decision you come up with, you will be able to demonstrate that there was both substantive and procedural fairness when handling that particular issue. I hope I'm right.
Yes, thank you.
Thank you.
Just to add more,
Okay.
these policies can be coined towards after this declaration. Such a person cannot be involved in decision making for the other individual. So such policies normally reflect such normally have such clauses.
All right. So declaration of conflict of interest, especially whereby you're likely to make a decision about the other person, or whereby maybe it might, now I'm getting where Milton is coming from. It will inform even issues to do with reporting relationships, deployment of this particular employee, so that you don't place me directly under this person who is my friend. Yeah, I think we are getting it. We are getting it clearer and clearer. Thank you, Milton, for that. Yes, Ms. Ochira, your hand is up.
Okay, good evening.
Good evening.
Yeah, thank you so much, Mercy, for the exposition. We also appreciate Milton for the additional contributions. My question is in regard to the recent court ruling about managing workplace relationships with regard to romantic relationships. The reason why organizations for the longest time have been cautious on this is also to help in implementation of safeguarding in as far as sexual harassment is concerned. So I'm just wondering, what is the experience of the rest of the participants, or what would be the counsel of Mercy as our facilitator in how to manage matter sexual harassment in the context of this recent ruling of non-interference on personal relationships? Thank you so much.
Thank you, Rhoda. And what I would like to say is that now already the court has made a determination. What we need to understand is what is sexual harassment? What are the provisions? And I think we need to look at the Sexual Offences Act in detail and understand what constitutes sexual harassment in the workplace. do we have policies also in organizations that define what sexual harassment is, so that we have very clear boundaries? Of course, sexual harassment is a serious offense, particularly in the workplace. So we need to understand what are the provisions of the sexual harassment in as far as the act is concerned, and we don't confuse that with consensual relationships from adults. Yeah. So if you're able to demonstrate, or if there's a complaint actually from the person who is alleging to have been harassed, that's a different story altogether, compared to what is a consensual relationship. Remember, in an employment space, you have adults. So both of them may occur. There could be incidences of sexual harassment which need to be treated as such, and there could be incidences of mutual consensual relationships. That is how I would want to look at it. Any comment on the floor? Yes, Richard.
In addition to what you've said very well, an organization needs to have a policy that guides sexual harassment. Actually, the Employment Act says an organization that has got more than 20 people must have a policy that guides the organization in understanding and determining what is sexual harassment. So the issue of consensual relationship is totally different from an issue where now somebody is using his power or resources to undermine somebody who is working under them. So an organization must have a clear-cut, very crystal clear process of dealing with sexual harassment. Now, in fact, for the longest time, people have had that thing of there is no fraternization in the organization until somebody decided to challenge that policy that has been within our policy books. Now it's a totally different. That is why, as Mercy said, that now we need to educate people on what to look at when we are determining a thing to be consensual and sexual harassment. So there is need for training, and those are some of the things I think Milton will tell us that an organization needs also to prove that it's training its people to understand what is sexual harassment, so that somebody is able to distinguish, am I being harassed, or this is something that I've done on my own volition. Over to you, Mercy or Milton.
Yeah, thank you, Richard. I think that's very clear, and I think we are on the same path, same line, wavelength of thinking. Sexual harassment is an offense. It has to be treated very, very, very differently as sexual harassment. I can see Tyson's hand is up, but before Tyson raises the concern, there was a question on whether, what was the question? There's something to do with handling disciplinary, whether you can reject resignation for a person who has already resigned. I think I'd rather have Milton go first before I give my practical comments.
Will you please pardon the question, because I don't have it on my chart? Okay.
So the question, I think, was whether you can, we had talked about resignation in terms of termination, and whether an employer has a right to not to accept. And we saw that the court has already ruled that once a person has resigned, provided they have given a notice or they have paid in lieu of notice, then as an employer, you have no obligation to reject that resignation. So the question is, how about if this employee has been undergoing disciplinary proceedings? And my take is, I think remember we are saying that if you reject that resignation, that then you're contravening the right to voluntary labor, the right to serving on a voluntary basis, which is protected under the Constitution. So for me, if a person resigns, whether or not the circumstances, number one is that this person has resigned. What I think then should be handled is what is the nature of the disciplinary case, and if it was leading towards termination, then I think we'll have no choice but to terminate those proceedings. However, if there was maybe a criminality in the disciplinary process, I think then the role now shifts to not from the HR but to the respective law enforcement agencies, so that now it is a police case that is being handled together, probably with it's handled as a criminal, issue, not a disciplinary case. Milton, I have attempted to respond practically, but maybe you can weigh in on what are the provisions in law, and maybe Richard as well.
You're very much right. The position is that an employee can resign at any point, whether it's during the disciplinary processes or whether it is not. In as much as the disciplinary processes were clearly leading to his termination, the employee can terminate his contract at any time that he pleases. In as much as it might lead to criminality or an offense, the employer has no business rejecting the resignation. In as much as it is a criminal offense, there's also the obligation of the employer to report it way before it even to the appropriate authorities, way before it even heads to the disciplinary processes. So proper procedure is that if it is leading towards a criminal offense, the employer can do his investigations. If the employee terminates his contract, well and good. The investigation report will come out and the employer can take the necessary procedure to prosecute his or her case.
Excellent, crystal clear. I think we are well guided in that regard. Do you have any other issue or question that we have not addressed? Going to look at the chat. I can see Milton has directed us to where rights that cannot be limited are. Go to Article 25 of the Constitution. You'll be able to see those very, very clearly. I think they're around 5 or 4. I want to believe that you have answered all questions, unless Mr. Magoma, you have anything from our wonderful participants.
Mercy Mwirigi, thank you very much for the enthusiasm, for the research, for the incisiveness that you have presented us this particular masterclass. I have learned a lot, and I am sure there is value for creating this moment for Hilary, Sarah, Mugira, Juliana. Thank you, Milton, Tyson, Gina, and many others that I cannot be able to see. What are your parting shots, Mercy?
My parting shot is that HR, it is still the most noble profession that I know about. I know Milton will not agree with me for now. However, my parting shot is that as HR practitioners, we need to stay ahead of the curve. Things are changing fast and furiously. Everything is changing, actually. So we have to be alive to the changes that are happening in the world. I already, in my concluding remarks, I said that we have not exhausted the changing landscape of the employment environment. We just handled one area and not exhaustively on the recent changes in law. So there are many other dynamics. So we have to stay ahead of the curve. Let's prioritize continuous learning, continuous training. Let us prioritize not only for ourselves, but for our seniors, because I know most of us may not be seniors, for our staff, so that we stay informed and we ensure that we are managing our employees the best way we can. Most importantly, let's understand our employers' requirements and needs. Let's be the drivers of the strategy through effective human capital management and development practices that are modern, that are innovative, and that are leveraged on best practices. Thank you so much, Richard. It was really nice to have you on board. Thank you for being my co-facilitator. And to everybody who has joined this evening, we really appreciate you. We value you. Should you have any other concerns, reach out to us, and we look forward to more exciting conversations and engagements. Thank you very, very much. And thank you, Milton, for also being very useful in responding to the legal concerns that we had. Thank you very much. And have a lovely Easter weekend, everybody. May the Lord bless you together with your loved ones. See you soon.
Thank you very much. Thank you very much, ladies and gentlemen. On a lighter note, Milton has to agree because we are the one who gives you these cases. We are noble. We are noble people. We are the ones who give you the records. We assist you in going to court. So we are noble. Victor, you do not have any other option other than to agree that we are the noble profession. Ladies and gentlemen, have yourself a good holiday and God bless you. Good night.
Thank you. Good night.
You too.
Thank you.
Thank you.